Welcome to our second Legislative Update webinar for the year. I know many of you are rejoining us on the heels of our earlier update in March, but for some of you this is your first walk down Legislative Lane with us. My name is Molly Kelly and I'll be your guide through the wild and woolly world of national, state, and local legislation. I've been in the human resource field for about 14 years, 6 years with Xenium, mostly recently in the role of HR business partner. As the outsourced or supplemental HR guru for over 30 clients, I'm expected to stay current on the constantly shifting sands of legislative decisions. While it's one of the pieces of my job that I love the most, I'm sure many of you can agree that it can be challenging to keep up with everything that's going on and then figure out how to implement these changes in the workplace. To help us in that effort, Xenium partners with many of the leading employment law firms here in the Pacific Northwest, and we constantly network with them to stay ahead of legislation. So while I'm not an attorney, I know some good ones. What we hope to do in the next half hour is distill that information down into bite-sized pieces to provide you with a bird's eye view of what changes have recently or are likely to occur. We'll have some Q&A at the end. Please type questions into the chat function, and my colleague Brandon Laws will help me moderate at the end to address any of your questions and concerns. Typically, we have one of these sessions per year. The fact that we're on our second one in 6 months is a sign of the climate of change that we're all navigating. We have a lot to cover in this session. We're going to start with the activity on a national level, then move to a more regional here in the Pacific Northwest, and then microcosmic with the City of Portland's paid sick leave. First, we'll take a quick look at healthcare reform. It's actually not medically recommended to take anything more than a quick look at healthcare reform right now, as further examination will give you a headache and maybe even ulcers. There's just so much information out there and it's constantly changing. There was a major recent development that we should address, and I promise it'll be perfectly safe to review it in a small dose. Dovetailing nicely with healthcare reform and equally as changeable are developments on the heels of the Supreme Court's recent ruling around DOMA, or the Defense of Marriage Act. There's still a lot of unknowns here as various federal agencies try to suss out the impact on their specific sphere of influence. But we'll cover some of the knowns and resolve some questions for you. National Labor Relations Board, lots of activity here now that their status is no longer suspect, as we'll discuss. So we'll take a look at what they have on their agenda, what their focus means for both union and non-union environments. The safety and fair treatment of all employees working in a given environment has been a focus of both the courts and OSHA lately, leading us to examine recommendations around safety and equality in the workplace, including Oregon interns. The majority of you are based in Oregon, and we'll be happy to know that we'll be covering new legislation for Oregon, as well as Portland's sick leave, which was recently clarified, just enough to answer some questions and raise many, many more. And be advised that we will be following up after the webinar with more follow-up in writing with links to some of these resources that I'm going to cite. And with that, we'll jump in. The Treasury Department announced in early July that it was delaying implementation of the employer mandate part of healthcare reform law for 1 year until January of 2015. Industry insiders cite one reason for the delay as the lack of confidence that employers are feeling around current regulations. There's a lot of speculation and not a lot of firm ground for people to stand on here. A key feature of the reform, often referred to as the pay or play mandate, was postponed. The rules behind it are still in place, but the tax that goes along with noncompliance is the piece that's being held off. The rules require large employers, those with 50 or more full-time equivalent employees, to either offer affordable health care coverage that provides minimum essential coverage and minimum value to their full-time employees, or risk paying an excise tax is what we're looking at here. The play or pay rules were scheduled to take effect on January 1st of 2014, but essentially the delay allows many employers to essentially have a dry run year where penalties won't kick in until 2015. Healthcare reform was not repealed overall, so this is a change to just the tax piece that was going to come into effect essentially in 2014. A number of mandates still are scheduled to take effect for plan years beginning in 2014, including a 90 calendar day cap on waiting periods, which may shorten waiting periods in some medical plans driving many plans to adopt a 60-day eligibility period to address those months in which there are 31 days. A prohibition on annual benefit limits and a cap on deductibles in small employer health insurance plans, and on out-of-pocket maximums in all medical plans. So those things are still taking effect. In addition, new rules prohibiting discrimination in favor of highly compensated individuals in insured medical plans may take effect. There's many experts that feel like these are coming for 2014. They've been pending since 2010. We're waiting on the IRS to issue guidance interpreting these rules, and this would be a big change, as I have a lot of clients that have plans that might have a lower deductible for owners or an accelerated eligibility period for newly hired executives, for example. Such exceptions would become a thing of the past in the interest of ensuring that all employees are offered the same benefits. Employers that discriminate in favor of a richer health plan for their highly comped employees in terms of eligibility or the plan design itself would face a tax. So be sure that you know who your highly comped employees are, and be careful of promises to new hires that might require revision whenever this piece of healthcare reform goes into effect. There's honestly so much happening here that it could be a webinar in and of itself. And as if we read your minds, it is. Last week, Brandon recorded a podcast with a leading attorney who has an area of focus on healthcare reform. The podcast is due to be posted on our website in the near future, so stay tuned for more information on healthcare reform. All employers, regardless of whether or not you offer a plan or what your employee headcount might be, must send the required healthcare exchange notice by October 1st, 2013, which, as you know, is just around the corner. The notice should be provided to all future hires after October 1st of 2013 as well. The Department of Labor has issued a model form available online, and we'll be sending you the link in our follow-up materials for that. For those of you procrastinators, that is just 22 days away, or 528 hours rather, to get this done, so get on it. It's possible that the Defense of Marriage Act, or DOMA, ruling actually helped bring about the delay in pay or play. Federal agencies themselves are clamoring for clarification, just like the rest of us, on regulations in the wake of the Supreme Court's determination that DOMA's definition of marriage and spouse was unlawful. Federal agency staff are already busy working on healthcare reform complexities, and were so before the DOMA decision, and many experts believe that the DOMA changes were the final straw and led to the delay of pay or play. On June 26 of 2013, in the U.S. v. Windsor, a divided U.S. Supreme Court held that a portion, not all, but a portion of the Federal Defense of Marriage Act, or DOMA, violates the Fifth Amendment of the U.S. Constitution. DOMA was enacted in 1996, and in the portion at issue defines marriage for purposes of federal law as only illegal between one man and one woman, and a spouse only as a person of the opposite sex who is a husband or wife. 5 justices felt that this section of DOMA is unconstitutional. The IRS recently helped clarify this decision because there were a lot of questions coming out of this as to what it would mean at a federal level. Effective September 16th of 2013, same-sex marriages legally performed in the United States are treated as marriages for federal tax law, regardless of where the individuals or their employer resides. This is important as individuals living in states which do not recognize same-sex marriage were previously uncertain of how to treat same-sex marriage for purposes of federal law. That means that the employees who pay for employer-provided health insurance for their same-sex spouse may treat these costs as excludable from federal income taxes, even if they live in a state that doesn't recognize their marriage. State income taxes are another matter, however, and will follow the decision of the state, essentially. Employers must determine whether an employee is legally married and participating on the group health plan for federal tax purposes, and if so, adjust that tax imputation and federal withholding accordingly. Employers should allow Section 125 pre-tax premium participation for legally married same-sex spouses. Keep in mind that DOMA provides equal rights for legally married individuals. Rules for unmarried domestic partners are not changing. The Department of Labor posted a revised FEMLA fact sheet clarifying that the Family Medical Leave Act, or FEMLA, their definition of spouse now includes same-sex spouses. where an individual resides in a state that recognizes same-sex marriage. So they're a little bit behind the IRS. This differs from the IRS, which wasn't concerned with the state of residence. That means that we need to pay special attention to an employee's state of residence in processing leave requests. Same-sex marriage is prohibited constitutionally in Oregon, but it's legal in Washington. An employee working in Washington but residing in Oregon does not have a federally recognized same-sex marriage under current law. This means that regardless of the state in which the employee was married, an employee residing in Oregon is not eligible for FEMLA leave to care for a same-sex spouse. All of this could and is likely to change, though, following some informal remarks made by the Labor Secretary suggesting that the Department of Labor would revise its FEMLA regulations to extend FEMLA rights to all legally married same-sex spouses, regardless of their state of residence. So this could become a moot point, but for the time being it is a factor. The decision also means that the immigration system will need to make changes as to how they have treated gay and lesbian U.S. citizens and lawful permanent residents who have traditionally been barred from obtaining immigration status for their non-citizen spouses. Again, this is a very hot and kind of currently unfolding issue, so stay tuned. On April 12th of 2013, the very day of my last legislative update, as if they knew I had predicted it, the House of Representatives passed legislation that would require the National Labor Relations Board to end any activities that needed a 3-member quorum for approval. They did not have the required number of approved members. They weren't down for long, though. For the first time in more than a decade, the NLRB is fully functional now after the Senate confirmed 5 nominees, 3 Democrats and 2 Republicans. Predictions vary as to what they will focus on, but they include the following areas in employee handbooks, which I guarantee one of these is somewhere in your current handbook. Advance authorization before engaging in the conduct at issue. Broad categories of prohibited or required conduct. Any language purporting to restrict internal wage or disciplinary discussion. Use of generic terms such as unprofessional, misleading, or inappropriate. Language compelling all employees to confine their concerns to management. Blanket confidentiality provisions within the context of internal investigations. At-will disclaimers precluding modification by anyone at any time. Solicitation restrictions extending beyond working time and working areas. Access rules reserving managerial discretion or requiring advance approval. And this English major's personal favorite of quote-unquote vague or ambiguous language, which I hate to admit appears in most employee handbooks that I read at some point in time. These are all areas of scrutiny potentially for the National Labor Relations Board. Other labor attorneys feel it likely that Weingarten rights, which currently enable union members to have a union representative or another employee with them in meetings with management, also might be extended to non-union members, as they were in the Carter and Clinton administrations. This could be another way the board asserts its influence in the increasing percentage of non-union workforces, which is 7%. Only 7% of the private workforce is unionized. In a recent case where an employee wore a T-shirt that depicted a ball and chain with the word slave written on it, created by a union during a prior bargaining period, an unfair labor practice charge was brought when the employee was told that he was violating the dress code and needed to go home. In order to avoid charges of unfair labor practices, make sure you're crafting your dress code policy language so that it provides legitimate business rationales for the dress standards, and be specific as to what clothing is impermissible. Target's employee handbook prohibited solicitations on company premises, and this is very common in handbooks that we see. Specifically, soliciting, distributing literature, selling merchandise, or conducting monetary transactions in cases when those activities were for personal profit or commercial purposes or charitable organizations. The NLRB took issue with this and ruled that the phrase could lead an employee to think that the policy prohibits solicitation and distributions for other organizations such as unions. They felt the policy violated Section 8 of the National Labor Relations Act, which prohibits an employer from interfering with or restraining an employee's rights under the law. So now that we know what the board is focused on, we can shift our focus to other agencies. In late April, OSHA announced an initiative to focus on the safety and health of temporary workers after recent high-profile temporary employee fatalities. Temporary employees often perform the most dangerous jobs, sometimes have limited English proficiency, and are frequently not receiving the training and protective measures required to keep them safe. Understandably, the feeling within OSHA is that employees must be safe, whether they've been on the job for one day or for 25 years, and regardless of their future status with the company. As a result, OSHA is directing field inspectors to make a concerted effort using enforcement, outreach, and training to ensure that temporary workers are protected from workplace hazards. Inspectors are asked to hone in on this issue during worksite inspections and will be specifically interviewing temporary workers on whether or not they've received safety training. Rather than relying solely on interviews and site visits to bring to light temporary and other safety issues, OSHA is also now moving to an online complaint gathering system. Previously, complainants had to provide written or oral complaints only, but this will now be available online. Not to be outdone, and in a bid to remain relevant in a world where people spend hours catapulting small birds at pigs, the Department of Labor has developed an app for smartphones. So there's an app for that. The agency is using technology to invite the public to assist in targeting a greater number of employers at a relatively low cost. Their newest app combines information from consumer review websites like Yelp with publicly available wage and hour and workplace safety enforcement data. It's like dirty dining for wage and hour complaints. Recently, a Department of Labor investigator received a call from a business owner who said, "You know, we've been going back and forth on these back wages violations and I just want to settle it." The investigator asked, "What made you change your mind?" The business owner's response, "That app out there, it's ruining my reputation with my customers." The wonders of technology, eh? Technology and its related challenges were on the minds of Oregonians, too. House Bill 2654B, signed by Governor Kitzhaber on May 22nd, limits employer access to personal social media accounts. Beginning on January 1st of 2014, it will be unlawful for employers to take a number of adverse actions against employees and applicants related to social media. The law prohibits employers from requiring employees and applicants to provide them with their username, password, and access to their personal social networking activity. This does not forbid employers from Googling employees and applicants. However, Google with caution. If you Google an employee and find something that touches on a protected class, such as a disability, same-gender relationship, whatever it might be, and they haven't shared that with you, and you then make an employment decision that doesn't go in their favor, i.e. you pass them over for promotion for someone more qualified, or you decide to hire someone with better Excel skills, you are now in the place of potentially having to prove that you didn't take action based on your knowledge of their protected class. So if it's an important part of your process to Google your applicants, have someone independent of the hiring process do the Googling. Ask them to relay only the information pertinent to the qualifications for the job. Those of you who joined us in our March legislative updates will be relieved to hear that the final version of this law permits an employer to conduct an investigation of misconduct based on receipt of specific information about employee activity within a personal social media account. Previously, that was that question as to whether an employer would be able to respond using social media for investigations. Employers have the right to protect company reputation as well as protect other employees from harassment. In general, we're finding that social media issues are becoming more and more frequent components of our harassment investigations here at Xenium. So knowing when to investigate personal social media use and when to leave well enough alone requires support from savvy legal or HR professionals. This remains a very fraught area. Veterans may now receive Veterans Day off through Senate Bill 1, signed by Governor Kitzhaber on April 2nd, and it's effective immediately, so effective this November. The new Veterans Day off law requires employers to allow employees who are veterans to take leave on Veterans Day, so long as the employee requests the day off 21 days in advance. The employer has the option of granting paid or unpaid leave. However, an employer is not required to grant leave if the leave would create a significant economic or operational disruption or undue hardship. So if an employer determines that it can't grant leave to all the veterans who have requested it, the employer may choose to either deny all of the leaves requested or deny leave only to the minimum number of veterans necessary to keep things flowing along smoothly. where an employer denies an employee request for leave based on disruption or hardship during the following year, the employer must allow the employee to choose another day to take off. So you're still needing to provide them with leave at some point. On June 6, 2013, Governor Kitzhaber signed into law House Bill 2903, which amends and adjusts an employee's eligibility to take leave under Oregon's domestic violence leave law. Around since 2007, the existing law provided victims of domestic violence, sexual assault, harassment, or stalking to either take paid or unpaid leave to seek legal or law enforcement assistance, medical treatment for or recover from injuries, obtain counseling or other victim services, or to move to a safer home. The law also extends similar protections to parents or guardians of a minor victim. Employers with 6 or more employees for 20 or more work weeks in a year are required to provide this type of leave. Originally, an employee had to work an average of more than 25 hours per week for the 180 days preceding the date of leave. That requirement has been lifted with this change. An employee of a covered employer will be eligible to take leave from the first day of their employment. Covered employers must also post a summary of the law in the workplace, so this is a new posting requirement as well. Make sure your policies are in place, that your managers have been trained, and that you have your poster up come January 1st. Direct deposit of paychecks is now permitted without prior employee consent under House Bill 2683B, signed by Governor Kitzhaber on June 13th and effective January 1st of 2014. But there's a catch. Direct deposit is often more efficient and affordable than paying an employee via paper checks. I would add the amount of blood, sweat, and tears that go into timing on final checks alone makes direct deposit a gift in separations at certain times. Current Oregon law permits direct deposit only where the employee agrees to that arrangement. The new bill permits employers to use direct deposit without prior consent from the employee, so it can be the default status essentially. However, upon request from the employer must provide the employee with payment by check. So there is an opt-out clause for folks who are attached to their live checks. You must still provide a physical itemized statement of deductions unless you've received individual employee consent to provide the statement electronically. In the category of no-brainers, Oregon interns are now protected from discrimination through House Bill 2669A, signed by Governor Kitzhaber on June 13th. This one is also in effect already and extends statutory protections against employment discrimination to interns. It expressly states that it doesn't create an employment relationship for purposes of wage and hour law. Thus, interns remain exempt from minimum wage and overtime laws so long as they meet the 6-factor test for interns. Treat interns the same as you would any other employee for the purposes of preventing discrimination, including providing your managers with harassment prevention training, ensuring the interns are familiar with your complaint reporting procedure, and ensuring that your intern selection process must be fair and provide for equal internship opportunities. In a landmark move, Oregon became the first state to require bereavement law. OFLA, or Oregon Family Medical Leave, which applies to those employers with 25 or more employees, was amended to include bereavement leave through House Bill 2950, signed into law on June 13th and effective January 1st of 2014. Within 60 days of receiving notice that a family member has died, an OFLA-eligible employee may take up to 2 weeks off to attend the funeral or alternative to a funeral, make arrangements necessitated by the death, or grieve the death of their family member. Family member here has the same definition as currently exists under OFLA. Note that this is not a paid leave per se, but employees may use their paid leave to cover the time. If an employee experiences the death of more than one family member in a year, the employee may take up to 2 weeks for each death. Bereavement leave counts towards the 12 weeks of total leave permitted under OFLA. It doesn't add any additional leave, in other words. Oregon employers have long become accustomed to tracking the more generous OFLA policy when the Federal Family Medical Leave Act, or FEMLA, does not provide for leave, and should remember that bereavement leave exists for OFLA only, and the time does not count towards the total amount of leave time permitted under FEMLA. Employees do not have to give advance notice of bereavement, so long as the employee gives an oral notice within 24 hours of taking the leave, or written notice within 3 days of returning to work. Any employees with the same family member are allowed to take concurrent leave, so they can take leave at the same time. Employers who already have policies permitting bereavement leave are encouraged to make sure that their policies comply with this new law. Portland paid sick leave. The day the administrative rules for the Portland paid sick leave were finally released, a collective groan went up from the HR team at Xenium. For months, we've been strategizing and speculating and hypothesizing with our clients about what the impact might be of the long-anticipated clarification around the ordinance. And at last, they were here in 12 pages of single-spaced convoluted language that in some respects raises more questions than it answers. The sick leave ordinance, as a reminder, goes into effect January 1st of 2014, requires all private sector employers with 6 or more employees to provide up to 40 hours of paid sick leave per year to employees working at least 240 hours in a calendar year within Portland city limits. Smaller employers with 5 or fewer employees must provide up to 40 hours of unpaid sick leave. Employees will accrue 1 hour of sick leave for every 30 hours worked within the Portland city limits, maxing out at 40 hours. An employee who telecommutes from a location within the city is covered by the ordinance, but an employee driving through the city without making a stop for work-related purposes is not. Additional clarification included temporary workers are considered an employee of the staffing agency for purposes of the ordinance. Employees begin accruing sick leave on January 1st of 2014 or at the commencement of their employment, whichever is earlier, regardless of whether they have worked 240 hours, but cannot use their sick leave until they've worked for at least 90 calendar days and a minimum of 240 hours. Many of our employers have paid time off policies and worried about how their combined sick and vacation policy would be impacted by the ordinance. PTO policies that meet the minimum requirements of the sick leave policy will not be an issue. The most likely adjustments might be around minimum eligibility and carryover, specifically that we must allow employees to carry over 40 hours of sick leave or PTO to the next year. Use it or lose it policies must be revised to allow someone sitting on a bank of paid leave to roll at minimum 40 hours of their accrued paid leave over. Another question has arisen around exhausting PTO for vacation. If I'm entitled up to 80 hours, let's say, of PTO and I use it all for vacation, that's my choice, and my employer has still met the minimum requirements for the ordinance. Employers, we'll send out a link essentially. Employers are still dealing with a lot of different factors on this leave, and there's a lot of confusion, or sick ordinance, so there's a lot of confusion around some of the specifications which are still up for comment. So we're in a comment period through November, so more could shift and change. We'll send out a full ordinance rule link to you. The rules also get into how the employer can calculate the number of their employees, how to address fluctuation in employee numbers, how to calculate pay, and the order in which an employee may use accrued paid leave versus unpaid sick leave. So that's a lot of information. So now what? There'll be new things tomorrow, and even more new things the day after tomorrow. So to keep you from feeling overwhelmed, consider the following. Assign someone in your organization to stay abreast of employer compliance updates. Ensure policies are updated to reflect regulatory changes, including required notices and communication to employees. Dust off the old handbook. Make sure it's been updated recently being the last 2 years and not sometimes in the 90s. Portland employers, make sure your sick leave and PTO policies meet the minimum qualifications for the sick leave ordinance and pay special attention to those carryover requirements. Train your supervisors, your managers, and your leads. Educate your employees on the new leaves, and make sure you get your healthcare reform notices out. Empower your team with knowledge. Share what we've covered today. Feel free to forward the link. Consult with an HR or legal professional, especially when you're implementing new policies, working through labor relations issues, or social media concerns. Thank you for your time and attention. I'll now turn it over to Brandon for any questions that folks might have as well.
Thank you, Molly, and great job on the webinar. At this time, I'd like to invite everybody to go to the chat window, and if you have any questions, feel free to enter them there. We already have a few questions, so we'll try to get to everything as the questions kind of roll in. I want to remind everybody that after the webinar, we will actually send out a follow-up email to those that attended with the PowerPoint slides, the audio recording, and the video recording. And then we'll also try to put together a little Word document with some links and other resources that could be helpful supporting this information. So Molly, let's start with the first question. And this first question comes from Emily. She wants to know about the lifetime benefit limits under ACA. Are they still allowed?
Lifetime benefits limits, I am not sure. I'm going to have to research that one for you, Emily. We're talking about healthcare reform, I'm assuming. And honestly, I'm not sure on that one, so we might have to circle back to you on that one. We have a benefits team right now here at Xenium that is researching feverishly every single day, every aspect of healthcare reform for all of our clients, and they are able to be accessed for questions at any point in time. Brandon also, as I mentioned in the podcast or in the webinar, has recently recorded a podcast with a healthcare reform expert that we'll be publishing probably within the week, maybe next week, that will have a lot more information as well too. It's a constantly shifting environment with a lot of different interpretations. I heard as recently as 3 or 4 weeks ago that the hours threshold for eligibility might even be changing. So the 30 hours that we're looking at right now might shift to 40 per some of the brokers that are working in this area. So there's a lot of kind of confusion and lack of certainty around this. So we're happy to kind of give you our current interpretation and then just make sure you're keeping really close tabs with your broker for current information, and also monitoring Xenium's website for additional podcasts and blogs as well.
Yeah, and as you mentioned, Molly, we have a lot of resources on healthcare reform on our blog right now. So if you go to xeniumhr.com/blog, you can actually run a search for different tags. And if you search for healthcare reform, there are a ton of recent articles that our benefits team has been putting out, and we also link to other attorneys' e-alerts and things like that. So you can get a lot of resources there. So let's get back to the questions. This one comes from Chris. Are employers also required to send out exchange notices to COBRA participants?
Good question. That's another one that I'm going to have to research, Chris. You guys are doing a great job of stumping me on healthcare reform here. My guess would be that since they are currently covered under an existing employer plan, that might be a good idea, but we can clarify with our benefits team and circle back to you for sure.
Great. Let's switch to the direct deposit law. Does the direct deposit law apply to final paychecks?
It does, yeah. There's sort of the legal guidelines, and then there's certainly an employee relations or process question when you talk about final paychecks, and that's regarding whether it be a mutual agreement to transition or a resignation where maybe there aren't any bad feelings, but certainly if there's a termination where you're terminating for cause, many folks feel that handing someone their final check is a best practice that's strongly advised. Certainly, direct deposit is very much foolproof, but many HR professionals prefer to hand over that final paycheck to just sort of have that whole wage and hour question at rest, where you're handing over that final paycheck within the guidelines required by each individual state final paycheck law. So wanting to make sure that you can kind of put an endpoint on that conversation and be done with it might preclude direct deposit, but direct deposit didn't have any, the new law doesn't have any limitations around final paychecks.
Let's stick with the direct deposit law questions for now. Another question is, do employers have to provide a paper copy of the check for the direct deposit law?
That actually was not part of the direct deposit law as it just came out, the new adjustment, but it actually was in place previously, and a lot of people are not aware of that. We've got a lot of employers who are really clamoring for a paperless environment, a paperless workplace, which works in many cases. Although I'll tell you, and my benefits team would agree, that that's been a real challenge with healthcare reform. There are some real restrictions around electronic dispersal of these required notices. And the same thing is true of wage and hour and paycheck issues, where sometimes there are folks who are just wedded to that live check or that piece of paper that shows them what their PTO balance is. Accessibility can also be an issue, so you've got folks who may not have access to a computer or who may not feel comfortable. So it becomes, again, kind of an employee relations issue where you want to make sure that you are customer service friendly and providing support for all of your employees, And certainly their paycheck is a big piece where they want to be able to access that information readily. And then Oregon law does provide that an employer must provide an itemized document, essentially noting what taxes have been taken out, so that what we would typically see as that kind of statement of earnings and things like that, that needs to be provided to an employee electronically or on paper. And if you're going to do it electronically, you have to notify all of your employees and make sure they consent to that as well too.
The next question comes from Wendy. She wants to know who is an eligible family member under the bereavement law.
Oh, okay. Good question, Wendy. So I'm going to try to do this by memory. It's the same group of folks that would currently qualify under OFLA. So we have a broader interpretation under OFLA than FEMLA. So it would be spouse, spouses, children, even folks like grandparents would be covered as well too. Many company bereavement policies go a step further and say, if there's someone who is essentially recognized in a similar relationship to a familial relationship, so maybe you were raised by your neighbor or your aunt or uncle, that you can take time off from that. So I would definitely point out that your company policy may override some of even the OFLA coverage pieces as well. You want to look for those two to be fairly similar so that you're not sending a mixed message. OFLA also does extend to pretty much, it's a very broad group. One group that is not covered that has come up quite frequently and that probably in a future legislative update we'll be providing you with is siblings. So right now, currently, your sister, your brother is not a covered party for taking family medical leave, and certainly not for bereavement. But we're likely to see that shift, and those parties will be added.
The next question comes from Molly. It's regarding Veterans Day off. She wants to know what is considered a year. Is it a rolling year from Veterans Day to Veterans Day, or is it a calendar year?
Good question, Molly, and I've actually been trying to suss that out myself. My sense right now is that it's a rolling year. There's two pieces of legislation that kind of seem to contradict each other, so I can definitely research that and actually probably reach out to one of our attorneys to clarify what they meant by that in the legislation, because there's two different pieces that kind of seem to contradict each other. But I think it is a rolling calendar year because, again, if we're talking about November, I think it's 11th, maybe it moves and shifts within the year, but essentially Veterans Day falling in November, it doesn't give you a lot of time, obviously. If we have to give them an alternate day off later in that calendar year, that might be a crunch. So my sense is that it's a rolling year, but we can confirm that when we follow up in our training follow-up as well.
Molly, you mentioned there's a lot more coming out regarding Portland sick leave. Do you know of any notification requirements that are regarding Portland sick leave at this point?
Yeah, there are actually. We will be sending along the general provisions, which I mentioned, which again are 12 pages of additional clarification, and there is a kind of a notice in here around both what kind of notification has to come from employees as well as what notification is required from employers. So in general, what we're recommending and what's required as well too is that employers shall provide written notice to all employees who work in the city of an employee's entitlement to sick time, the amount of sick time and the terms of its use guaranteed under the ordinance. The prohibition of retaliation against employees who request or use sick time, and an employee's right to file a complaint if sick time as required by the ordinance is denied by the employer, or if the employee is retaliated against. Unfortunately, they're not really clear about how or when that notice shall be provided. So right now, Portland, the ordinance essentially is in a review period where employers can provide comments as well as employees and various other interested parties. So it's still a shifting, changing landscape where essentially we're trying to clarify a lot of these points, and certainly the 12 pages of additional administrative rules have helped answer some questions. Many of our employers and frankly many HR professionals feel that there's a lot of clarification yet to nail down, and that unfortunately some of it will probably come in the next year as we encounter various difficulties in trying to get through this process. So that's one piece that still remains out there. They're very clear about the penalties, which I won't bother to read to you. So there's penalties out there for not providing notice, but as to when it will be required, I'm not seeing anything on that right now. So good question.
We've got a couple more questions about the Veterans Day off policy. Can employers, let's see if I'm reading this correctly, for Washington employers who have a limited staff in Oregon, does the Veterans Day off policy only apply to Oregon employees? That's the question.
That's a good question. And, I think it is specific to Oregon. However, this becomes, again, another matter of employee relations. If you have a staff that's tightly knit and you're essentially acknowledging and honoring Veterans Leave for Oregon, there becomes a fairly good argument from an employee relations standpoint, not from a, what's required by law, but an employee relations standpoint, that if you have a request coming in from an employee in Washington who's not currently covered by any sort of Veterans Leave, where they want to take time off for the purpose of the law, which is essentially to honor veterans' activity. They might be returning to their base, they might be going to a parade, they might be visiting a cemetery of some sort, or just essentially processing the experience of having been a veteran. That you really should strongly consider that in the sense of wanting to make sure that we're offering equal support to folks, even given a state boundary. I wouldn't let that come between your consideration of that request. That's a really good question.
The other question regarding the Veterans Day off is from Sherry. She wants to know, what is the best way to notify veterans of their right to request the day off? And to just notify all employees in general as well. Yeah,
that's a really good question. And again, it's not something that you're necessarily going to know who fits or who doesn't fit. The definition of veteran and service is pretty broad. We can certainly send along the requirements within our follow-up as well too. But essentially, we're recommending updating your handbook policies as soon as possible. So Xenium has a sample leave policy. All Xenium clients and even non-clients are welcome to reach out to me after the session through info@xeniumhr.com to get a copy of that policy, because we really feel it's important to educate folks proactively. We're midway through September and these requests are due 21 days prior to Veterans Day. Potentially having a staff meeting where you announce the fact that that leave is pending, and rolling it out that way. There may be something online, I'm not positive, but there may be something online that would be a poster that we could print. There's no required posting as of right now, but my hope that there would be something that would be fairly user-friendly that would be something you could put up for employees, but making sure that they're aware of it is a huge piece of that proactive communication, since it's just around the corner.
The other part of the question that Sherry actually had was whether the veteran has to take their own PTO or if it's unpaid. Can you shed some light on that, maybe just clarify?
Yeah, I'm not sure, Sherry. That's a really good question. So typically within other similar state leaves, so Oregon Family Medical Leave, for example, the only requirement employers have is that they must allow an employee to take leave. So if I had PTO in my bank and I had a new baby and I wanted to take 2 weeks of PTO, Xenium couldn't forbid me from doing so. But there actually is there's no caveat to an employee saying, I want to sit on my bank of leave, I want to keep those 2 weeks from when I come back from leave, and then I want to take the leave down the road. Xenium can also say to Molly, Molly, enjoy this time with your baby and we will be paying out your PTO. So my assumption would be that the same thing would be holding true here of Veterans Leave, where if somebody took a day off, we could potentially apply any paid leave, vacation, what have you, that they have in their bank, but I'm not positive. So we can definitely research that and just circle back to you.
Okay, we have several more questions, but we're running out of time, so we'll go with one more. And then for those that would like to reach out to us, you can reach out at info@xeniumhr.com, and we'll be sure to route those questions to Molly. The last one, again, Veterans Day, we'll stick with that. For Veterans Day, the non-veterans who are requesting time off, how does that approval process work?
I'm sorry, Brandon, can you repeat the question again?
Yeah, so for the time off that is requested by veterans versus non-veterans, how should an approval process work?
Oh, good question. I love process thinking. I would be in favor of adjusting whatever time off request form you are using currently for your employees to include, if you don't already, a spot for leave. So whether they could write in, if it's FEMLA, it's OFLA. Most employees don't think in that terms of, that kind of term of language, but they might know the word, or, the word leave, essentially a leave of absence. And even maybe spelling it out for them and noting, is it family medical leave, or is it, Veterans Day or some other type of leave? You're not going to have an employee who's going to feel comfortable signing a box that says domestic violence leave. I mean, I'm just going to tell you that right outright. Generally, that's going to be a more private situation. So you may not want to get too specific, but somehow including some form of leave request process versus an informal conversation is often recommended. But the other alternative to that is, just making sure that your managers, your supervisors, are really well trained on what leave law looks like. They don't have to know all the specifics about who qualifies for what, but making sure that they are very aggressively informed about new leave law and the fact that their employees qualify for it, because often, long before a piece of paper shows up in an inbox, there's a conversation around, I'd like to take this day off, is that a possibility? In all of the hubbub of healthcare reform and Portland sick leave and all kinds of other legislative and legal changes, most employees are not aware of veterans leave. So, Sherry's question of how do we notify veterans of the leave's existence, making sure that your managers are aware of it and that employees know it exists, and then allowing that conversation to happen or creating a form around it makes a lot of sense to me.
Thank you, Molly. And as a reminder, we will send out the slides, audio and video of this webinar to everybody by Friday. Thank you all for attending. Molly, if you have any parting thoughts, we'd love to hear them.
Oh, great. Again, you're absolutely serving yourselves well by tuning into this and similar other podcasts, webinars. There's lots and lots of training material out there on all of these various issues. Also, signing up for legal alerts from the leading employment law firms can be really beneficial. And we're, of course, thrilled to be your source of information for this particular round. And I look forward to connecting with you in the future. Thank you.
Thank you. Thanks, everybody.